Hey guys, and welcome to the weekly Docket. In Wisconsin, let's take a look at Taylor Schabusiness. She's awaiting trial right now for dismembering her boyfriend after a romantic interlude. Imagine what she'd do if she didn't like you. The last time we visited Taylor, she was foregoing leaving a bad Yelp review and instead taking a more personal approach with her dissatisfaction over services rendered by attacking her attorney in court. The attorney, not surprisingly, filed a motion to withdraw, which was granted, and a new attorney is on the case now. The judge found Schabusiness competent to continue toward trial. The judge also faced a motion to recuse himself based on seeing Schabusiness attack her old attorney. The judge denied that motion, saying, look, hey, I can still be fair toward her. It's a nice thought, though, that she could basically force a change out of court personnel by getting violent in court. This judge can't be fair because I decide to attack people in front of him. He might think I'm the kind of person who might attack people. So I need a different judge unless I attack someone in front of them too. Yeah, no. She's also asked for a change of venue through the new active attorney. I don't see ruling on this yet, but the Magic 8 Ball says signs point to no. Despite internet lore that evidence should be super secret, and if any reporting has been done, the trial should be held in the Amazonian rainforest by a tribe previously uncontacted by civilized peoples, that's just not how it is. A juror is not even automatically disqualified if they've heard of or read about the case. A judge has several mitigation tools to deal with a case that has had a lot of publicity, and to what extent the judge uses those tools, it just depends to some degree on the nature of the publicity. Accurate reporting on facts is not inherently unduly prejudicial. Frothy mouth opinion pieces certainly could be. So like many things in the law, it depends, but publicity does not equal change of venue. The judge has to consider several factors and then make a decision. This takes us over to Idaho and the reporting that the executed search warrant against Bryan Kohberger in Pennsylvania resulted in an ID associated with the house that was the scene of the crime being found. Now, the search warrant did say IDs were seized from inside a glove that was inside a box. And that sounds kind of suspicious, but who knows? And it also seems kind of plural. So how many IDs and from who were in this glove inside of this box? But it does not say whose IDs those were. So did police seize an ID in Pennsylvania that was related to the murder house? I don't know. Given the way the report has come out, I wouldn't take it as completely solid. But, oh my God, shouldn't everything be secret in the gag order? Oh my God. People citing the gag order have missed only 2 steps. They haven't read it and they don't understand it. Other than that, fine job. Courts have jurisdictional limits. They have to abide by those when they issue orders. For example, a court in Montana does not just issue orders, say, forbidding actions by people in Florida who've never been to Montana and aren't doing anything in Montana. They don't have jurisdiction. Gag orders have additional limits because they limit free speech and they impinge on the public keeping an eye on what the courts are doing and doing to people. Now, the rise of our government should be able to do everything in secret trolls on social media has not changed the law. So if you read the actual order from the judge, whose job it is to know what she's doing, you will see that the order is fairly limited on who is bound by it. Attorneys for interested parties in the case, and that includes witnesses and victims or the victim's family, the attorneys for those people, not those people themselves. The parties themselves, that's the state of Idaho and its agents and Bryan Kohberger. And that includes the prosecuting attorney, the defense attorney, and law enforcement personnel, agents, and investigators. So this is not a national ban on anyone anywhere talking about the case. Like I said, it doesn't prohibit the witnesses or the victims' families from talking. It just prohibits their attorneys from talking, just as one example. So the prohibitions are limited to the people and entities specified in the order. As far as law enforcement inside Idaho, yes. Outside, no. Media, no. So if you're covered by the order, then you're limited in what you can say, as the order specifies in paragraph 1 and 2. But first, you have to be covered by it. Whether you're saying something that's against the order only matters if you're covered by the order. Now, even with those limitations, media has filed a lawsuit to eliminate or reduce the scope of the order because they say it actually covers things that the law says the judge can't, or shouldn't be restricting. And it also introduces a chilling effect to people or topics likely not covered by the order, with people saying, hey, I have no comment due to this gag order. Now, that case is still pending at the Idaho Supreme Court. But note my primary point here in the DA's office to the Supreme Court when they say in their brief that many people can claim and will claim to be bound by the order, but the scope is far more limited. Then they say, hey, just check out page 3 and 4 of the media's brief and look, and you'll find people and agencies not in the scope of the order saying they won't talk because of the order. And that includes victims' families, Washington law enforcement, and Pennsylvania law enforcement. So that's the state saying, look, these are people that aren't even covered by this order. And that's because the order is not directed at those people, even if they think it is, or just want to say that so they don't have to talk to the press. It's a limited jurisdiction order. Now, gag orders can be lawful if they're done carefully and correctly. So I doubt if anything happens here at the state Supreme Court. And if it is, maybe they just restrict the scope of the order some more or void it with some guidance to the judge on what needs to be fixed, more findings of fact or narrower scope or whatever. And then a new order comes right out if that happens. So I don't see there being no gag order in this case. That would be a surprise to me. The point of this discussion is that just because someone screeches about a gag order does not mean it applies. It's not a national ban gag order applying to everybody. So even if it doesn't get changed, it doesn't apply to media or a lot of people who might be interested in talking about the case who know something about the case. Still, if you don't have solid sources, it's better to not run with rumors. Let's head over to Michigan and talk about the Ethan Crumbley case. His parents, as we discussed earlier, they're facing trial for their actions involving purchasing their mentally ill minor son a firearm, not storing it safely, allowing him to get a hold of it, basically creating a situation to enable him to carry out his violent fantasy. Now, as I've said, it's at the limit of the law for reasons we've previously discussed, proximate cause. And it came onto this case because people were comparing it to the mother, Darrell Brooks, which I also analyzed via proximate cause. And this case was also compared to the case in Virginia where the kid took his mother's gun to school and shot a teacher. And fortunately, she wasn't killed, but still it was a disaster. And then people were saying, oh my God, they haven't charged her. Look at the discrimination in the system. This is terrible. Well, good news for case comparers. She now has been charged with failing to secure the firearm because Virginia has that statute, even though Michigan does not, the safe storage law. And she's been charged with felony child neglect. So she's got 2 charges against her. And she has, it is reported, which is also different than the Crumbleys, cooperated with police during the entire process. The teacher has filed a lawsuit in that case against the school alleging acts which, if they're true, ought to put some individual employees in very hot water. A termination, a resignation, and a reassignment are already on the books for some of those people. It's possible other people could face charges. The wounded teacher alleges that the school had noticed that the boy, who apparently had very serious, severe behavior problems and had to be accompanied by an adult all the time, even though he wasn't that day, that he actually had a gun that day. The school knew it, didn't do anything about it, and worse than that, they prohibited other people in the school from searching the backpack and checking to see if there was a gun and taking it away, saying, hey, his mother's coming soon, leave him alone. So I don't know if that's true or not, but boy, does it sound bad. So we'll have to see how that lawsuit goes. Now let's finish it up in Wisconsin, the nation's reigning capital right now for TV trials, and take a look at everybody's favorite Darrell Brooks, who had his restitution hearing yesterday. And that hearing resulted in kind of no surprise. The documents were all filed under seal, but restitution is not punishment, as I talked about in the previous video. It's not a full-scale recoupment of damages. And for the most part, I think pretty much all of it was insurance companies with subrogation claims, and then also a little bit more money for the victims' compensation fund. But the judge did say, I know he's broke, and we can all agree on that, but I'm still ordering all this extra restitution, and lobbed, I think, well over $300,000, maybe close to $400,000 from my first glance of it. I'll show the ruling here. Onto his restitution on top of what he already had. So he's kind of like the Titanic if it was already at the bottom of the ocean and slipped off a cliff and went down another 100 feet. He's a little deeper. It doesn't really change his outlook in life. One thing that stood out was the rate of repayment. The judge said the statute caps the rate at 25%. So I suppose she'll make that the order in the judgment of conviction.
Account. Now, I'd remind everyone that the law caps what that deduction will be at 25%. I think that's a very clear recognition by our legislature of the balance that the system needs to have as it relates to prison monies.
What's interesting is the Department of Correction takes a different position and says it can take up to 50%. That's what we discussed in the prior video. After hearing the judge in this case looked at the appellate decisions in 2 cases went up to the Court of Appeals last year on the issue of whether a court could order 25% specifically, overriding the Department of Correction policy of taking up to 50%. So in one case, the judge said you can take 25% of the wages, or that's what you will take. Didn't mention any other money. In the other case, the judge said you can take 25% or you will take 25% of the wages and 25% of any other money the person gets. So the Court of Appeals said, yes, the court can override the Department of Corrections there. But they never referenced any statute saying, hey, there's a cap here of 25%. They justified the ruling purely on the basis that the judgment of conviction set the amount specifically. So I'm not sure what cap the judge is talking about here. Also, in one case, as I said, the Court of Appeals said that because the judgment of conviction didn't mention gifts, the Department of Correction could take that at a reasonable percentage up to its policy of 50%. But in the case where the court said, no, I'm capping both of those at 25%, I'm making them 25%, the court said that's all you can take. So basically they said, yeah, Department of Correction can set the amount unless the court says otherwise. Again, no mention of a statutory limit. Maybe there's some new law. I just don't know what it is. That's possible. So while I'm not sure what cap she's talking about, and that doesn't mean there isn't one, for example, post-incarceration wage garnishment is limited to 20%. It doesn't matter if that's what she orders because I think that settles it. I think she has that authority. Now, there could be more litigation by the Department of Correction on the newer statute that says they get to decide a reasonable amount. But I think based on Court of Appeals logic in the 2 cases I cited, the idea that the department gets to decide unless the judge specifically states it, that's going to be the rule going forward in all likelihood. A final item that came up in comments, remember beyond restitution, which is not designed to cover all damages victims face. It's pretty limited. Victims can obtain civil judgments. The judge referenced the Wisconsin version of the Son of Sam law in an escrow account. It appears that if something occurs that causes such an account to be created and funded, victims have 3 years from that to file suit. So it's like an extended statute of limitations or a told statute of limitations. So if they do choose not to sue now, that might be a window for them later. For lots of reasons, it would be, I think, wise to do it now, but it's easier to get a contingency lawyer if there's a prospect of payment, of course. Though in this case, I think many lawyers would handle it for them regardless. At any rate, that's the end of the restitution drama, and the particulars of it would be in the written judgment of conviction that we haven't seen. Whether it's 25% or more, although she said 25% based on what he makes now, it really doesn't matter, does it? Because in this universe, I think he stays broke. That's it for this week. Thanks, bye.